Hello, here's my annual pre-exam update. I'm mostly following what's in the University of London's pre-exam update, on the assumption that they know what you need to know, but I hope I can make it a bit more comprehensible. Unfortunately, we've got to start with Brexit, although actually it's not going to make a great deal of difference to your exam. Brexit Day, as we all know I think, was the 31st of January 2020, but then there was a transition period which ended on the 31st of December 2020, actually at 11 o'clock in the evening, because of course that was midnight in Brussels, start of the new year, so we took back control at a time convenient to the European Union. 31st December 2020 is referred to as IP completion day for our purposes, if we were looking at the legislation, which actually I urge you not to bother with. There's a great deal of new legislation giving effect to Brexit, and it's minutely detailed. But having spent a lot of time looking at quite a lot of it, I can tell you that it affects practice more than it affects the substantive law. So you can ignore it. You do, however, need to understand what's happening with all the law that we got from the European Union during our membership. And the short answer to that is that legislation derived from EU law continues unchanged. Directives had already become part of UK law. The Trademarks Act 1994 implements the Trademarks Directive, and there are other pieces of primary legislation which are relevant. Then there are amending statutory instruments, such as the Duration of Copyright and Rights in Performances Regulation 1995, which increased the copyright term. Well, they already were UK law, so there's no need to do anything dramatic there at all. But there are other elements of EU law which need to be dealt with, and the whole acquis, as it's referred to, of EU law stays in our legal system, and it is given the name retained EU law. That seems to me to be a fairly flexible category, depending on who you're speaking to and what they want it to mean, but the concept is fairly clear. Part of the idea of retained EU law is that the interpretation of directives and so on by the EU courts, the Court of Justice and the General Court, remains binding until such time as the UK courts, and that's the appellate courts, not the lower courts, depart from it. But any new judgments coming from the EU courts are not binding on the UK courts, and they can safely ignore them. I think judges will very often find that it's convenient to follow EU cases, but the point is they don't have to. As well as the treatment of EU legislation post-Brexit, we also have to consider pan-European rights after we've left the European Union. But you don't have to very much, because EU trademarks and community designs are specifically outside the London University syllabus, which basically tells you that you need to know that they exist, but you don't need to know in detail how they work. Following Brexit, the protection given in the UK by these EU-wide rights is going to continue through the automatic creation of what are referred to as comparable UK trademarks and what are referred to as re-registered designs. There is a huge amount of legislation dealing with what happens if you've got an outstanding application for an EU trademark on IP completion day, for example. What if you've got an unregistered license? All kinds of important detailed points which you can safely ignore, at least for the purposes of your exam. We also have to consider community unregistered design rights, but again, only in passing. These rights, so far as they had any effect in the United Kingdom, turn into continuing unregistered designs, and any future designs are going to be protected by so-called supplementary unregistered design right, or SUD. This is completely separate from the UK's own domestic design right, or unregistered design right, as it's sometimes inaccurately called. Brexit has actually surprisingly little effect on UK intellectual property rights. I think there are two important areas that you need to know about. First of all, the qualification rules for design right aren't changed. So EEA nationals and residents still qualify for protection, and first marketing in the EEA still counts if the design doesn't qualify for protection by reference to its designer. Secondly, the exhaustion rule rights are still exhausted when goods are placed on the market in the EEA by the right holder or with their consent. Actually, at the time of recording this, the UK government is consulting on changing the rules about exhaustion, but that's certainly not something that's going to be a problem for you in the exam. In the field of patents, of course, the implications for Brexit are fairly small because the European Patent Convention, being a non-EU instrument, continues to have effect in the UK quite unchanged. However, it does mean that EU proposals for a unified patent court are no longer of any interest to us. Well, the government did prevaricate about that for a while, but eventually came to the conclusion that it didn't want to take part because the Court of Justice would be involved in the process. And it also means that when the EU patent comes along as a sort of graft onto the European patent system, although it'll be possible for UK applicants to get EU patents won't give protection in the UK, so it'll be necessary to get a UK patent as a separate exercise, or designate the UK separately in a European patent application. We'll move on now to look at some substantive law, and these topics come up in the order in which they're presented to you in the module guide. Beginning with the case about final injunctions, the examiner never gets particularly bothered about remedies per se, but they do crop up from time to time. This harks back to a case from 2017, Edwards Life Sciences against Boston Scientific, which reminds us that a final injunction is discretionary, and in that case the public interest prevailed on the basis that granting the injunction would potentially endanger the lives of certain patients who relied on the device that had now been found to infringe, and the judge exercised discretion not to give a final injunction. In 2020, it looks very much as if the claimant who didn't get their injunction in that case was a defendant in another case and tried the same argument. But in this case, the injunction was granted because there was no objective need to protect patients. It was just a matter of doctors' preferences. The argument being that no injunction should be granted because some doctors preferred to prescribe or to use the infringing product. Moving on to breach of confidence, a Court of Appeal judgment is always an important thing, and a judgment of Lord Justice Arnold, as he now is also going to be important in itself. And now that he's not giving first instance judgments, he doesn't have to make them quite so long. Shenzhen Technology Material Company Limited against Celgard considers the impact of the Trade Secrets Directive, and it doesn't get into it in any great detail, but it does say that where existing principles of UK law on breach of confidence give greater protection, the directive doesn't in any way curtail that protection. Well, it was always thought that the directive gave less protection than existing UK law anyway, and therefore it wasn't a big deal to implement it. So this amounts really to judicial recognition of the fact, and it means, I suppose, that the usefulness of the directive is that other countries in Europe are at a similar level of protection to the UK. Breach of confidence also embraces misuse of personal information, or privacy, which of course is, although it's now a distinct right of action, it started life as a species of breach of confidence. ZXC against Bloomberg explores the reasonable expectation of privacy of a person who's under investigation for criminal offences, and the Court of Appeal confirms that such a person does have a reasonable expectation of privacy. And in a case like this, which is only concerned with provisional suspicions, and it's turned on the disclosure of a letter from the UK authorities to the authorities in another country asking for information to enable them to decide whether there was a criminal issue at all. In those circumstances, it's reasonable to expect privacy. And indeed, the court said that the public interest lies in favour of maintaining confidentiality of such a request by the authorities. Then there's also the Duchess of Sussex against Associated Newspapers case, a case with many aspects, most of which have come to fruition since the cut-off date for the exam. But in this judgment, the High Court's made it clear that the claimant doesn't have to show dishonesty, malice or bad faith, that the misuse of personal information could have taken place notwithstanding the fact that the defendant thought it was okay and did so in good faith. One of the trickiest areas in breach of confidence law, and particularly in trade secrets law, concerns the treatment of ex-employees, who of course walk out of their employer's door, or their ex-employer's door, with heads full of confidential information. And the Shenzhen case that I referred to earlier also has something to say about this aspect. Lord Justice Arnold reiterates the importance of the Coco case as a starting point for any breach of confidence case in general, and specifically for ex-employees, the Fachenda case and the Lancashire Fires case. So nothing startling so far. The important thing in this case is that in spite of the fact that it's incumbent on the claimant to particularise the information on which their claim is based, it has to be recognised that they need some leeway where they've got a particularly obstructive defendant or the defendant fails to cooperate. In those circumstances, it might be difficult to particularise what your claim is about in quite the detail that the court would ideally like, and they've got to recognise that. So certainly an interesting point for practitioners, but probably less of an interesting point for students because it's rather more procedural than substantive, I'd say. Another really difficult area for breach of confidence is third-party recipients, and the Court of Appeal had to look at this in Racing Partnership against Sports Information Services. The defendant was accused of breach of confidence, but the information that it shouldn't have had, it had got from a respectable third party who had access to the claimant's racecourses. More than that, the third party had actually given a warranty that the information wasn't subject to any confidentiality obligations in favour of the claimant. And the Court of Appeal, I think, reversing the judgment at first instance, thought that the defendant had done what they needed to do to put themselves in the clear. They weren't in breach of confidence. Commercial realities and efficiency, they said, dictated that the defendant should not be held beyond notice that the information was supplied in breach of confidence. That warranty, I think, was very important there. The defendant should not be held liable for acting on the strength of the assurances that they'd received from the third party, and a reasonable commercial party in the position of the defendant could not have been expected to do more. The advice of the claimant must be to go after the third party, not the party that's innocently received that information. But of course there are always practical reasons why that's not going to work. The correct defendant might have gone into liquidation, might be a foreign company, might not have deep enough pockets to be worth suing, all kinds of things. Next we'll turn our attention to copyright and the wonderful Brompton Bicycles case, a decision of the Court of Justice where it expressly links the idea-expression dichotomy and the idea of originality, telling us that there can be no originality where the realisation of a subject matter has been dictated by technical considerations, rules or other constraints which have left no room for creative freedom, or room so limited that the idea and its expression become indissociable. I wasn't sure about that word when I first read it, whether the Court of Justice had invented it, but the Oxford English Dictionary tells me it's okay. This is, of course, very like the concept of design freedom in design law, although it's being put to a somewhat different use. One highly topical issue in copyright at the moment is whether it's legitimate for us to have different categories of copyright work in UK law. That's possibly in conflict with the Information Society Directive, possibly in conflict with, well, as interpreted in the Info Pact decision of the Court of Justice. Most other European countries have an open copyright approach to copyright rather than a closed list approach. It's an issue which appeared in a case in the Intellectual Property Enterprise Court last year called Response Clothing against Edinburgh Woolen Mill, in which His Honour Judge Hakon acknowledged that there is doubt about the closed list system, but perhaps fortunately for him, he didn't have to go there, because the clothing design which was involved in this case satisfied the definition of a work of artistic craftsmanship under the 1988 Act, and it was also clearly a work in the Court of Justice's understanding of it as well, so a work under the European Union acquis. But it serves to remind us that this is very much a live issue, and if it's a live issue, then the examiner might like to ask about it. Indeed has done in the fairly recent past. In the response case, the judge also considered the definition of a work of artistic craftsmanship, and as you will no doubt remember, this is a very tricky area where we've got a relatively small number of very difficult to reconcile judgments from the English courts. In the response case, His Honour Judge Hakon chose to adopt a definition from the New Zealand courts, a bond group against Cook, a 1994 case in the New Zealand High Court, and the judge, Mr. Justice Tipping there, or could be Mrs. Justice Tipping, I don't know, considered the relevant cases, including the Hensher and Restawhile case, and said, for a work to be regarded as one of artistic craftsmanship, it must be possible fairly to say that the author was both a craftsman and an artist. A craftsman is a person who makes something in a skillful way and takes justified pride in their workmanship. An artist is a person with creative ability who produces something which has aesthetic appeal. Well, that makes a great deal of sense, and one interesting aspect of it, and an aspect which the courts have considered several times, is whether the craftsmanship and the artistic input have got to come from the same person. The New Zealand judge clearly seems to be saying it does have to be the same person. However, if this was a 1994 case, Vermaat and Bonkrest was 7 years later, and in that case the court specifically said that they don't have to be the same person. So that means there's quite a lot more to unpack in this case, but it's probably not worth unpacking it at the moment, because this seems to be a very junior court, differing from much higher courts. So it's an interesting statement of the law and an interesting interpretation, but I wonder how much ice it would cut, and therefore how worthwhile it would be throwing it into an exam, except to show that the examiner that you're aware of the latest developments. Having said that, there are a few other points which emerged from that case. The judge also said that it's possible for an author to make a work of artistic craftsmanship using a machine. Aesthetic appeal can be of a nature which causes a work to appeal to potential customers. I thought it's pretty obvious that that's a function of making something aesthetic. Anyway, and a work's not precluded from being a work of artistic craftsmanship simply because multiple copies are subsequently made and marketed. A mass-produced article's never going to be a work of artistic craftsmanship, I don't think, but there's no reason why you can't have mass-produced copies of something which still qualifies as a work of artistic craftsmanship because it's only been made in very limited numbers. So the response case is certainly one to which you would refer as authority for some propositions about works of artistic craftsmanship, even if that New Zealand definition might be a bit dodgy. Next we come to copyright infringements, and the big area of activity here seems to be what amounts of communication to the public, usually, but not always, involving hyperlinks. I've reversed the order of the cases from what's in the University of London's publication for my own convenience. I'm going to start with Warner Music UK Limited against TuneIn Inc. TuneIn's business was to run a website aggregating links to radio stations around the world and making it easy for UK listeners to listen to what those radio stations were broadcasting. Something that the internet has, well, made possible for the first time, although it's been going on for quite a long time now. Of course, the radio stations are playing largely copyright content in the form of music and sound recordings. Some of them have probably got a license to broadcast to their own countries. Some of them have got a license to broadcast more widely than that. Probably some of them are operating without a license at all. In the Svensson and GS Media cases, the Court of Justice has developed some jurisprudence about what constitutes a communication to the public and therefore requires the consent of the copyright owner. And basically it turns on the question of whether providing a link to the copyright material delivers it to a new public. So you might call this, instead of calling it communication to the public, call it communication to a new public. Anyway, what's going on here? It's a decision of the High Court, Mr. Justice Burse, who took this statement about the new public and applied it in the case of a link to a work which is lawfully displayed on the original website, which is located outside the UK, as a result of a statutory permission in the other jurisdiction only. Many broadcasters operate like this. They have a statutory license to use material in their broadcasts, and that statutory license only covers them in their own jurisdiction, so broadcasting to the UK is not something that's permitted. So Mr. Justice Burse says that the important thing to do here is to consider the scope of what the claimant consented to originally when they consented to the original posting. So when the material was made available on the foreign website or through the foreign radio station, what was it that that the claimant, that the copyright owner, was deemed to be consenting to? And of course it is deemed consent here because it was a statutory license. Well, of course it's no longer a simple matter of saying, well, I said that the radio station could broadcast it and they could do that in their own territory. The internet has changed all that, and the judge said that the claimant has got to be deemed to have consented to access by normal search engines, but not to access by a commercial aggregating service. That's a different kettle of fish altogether than somebody using search engine of their choice. I won't mention the G word, let me mention Nicosia instead, because they plant trees when people use their search engine. Go and find that. You can't get away from the reach of search engines, but you ought to be able to get away from the reach of people like TuneIn, who are setting up a commercial service to go and trawl the internet and find these links and push them to other people. So what TuneIn were doing did amount to an unauthorized communication to the public. The other case in this linking area is Wheat against Google. Now, the claimant took exception to Google's so-called hot links, which don't just provide a link but also display the website they're linked to in the page that you're coming from. So it's a kind of step beyond mere simple linking. The claim disposed of quite easily by the judge, saying that Google's hot links are not communicating the claimant's work to a new public. They're just presenting it to the same public that had access to it in the first place. So we've got these two cases in the High Court, one of which says that there is an infringement, the other says there isn't. So how do you reconcile these? And the key question is to ask what the copyright owner is deemed to be consenting to, which I think you could put in a slightly different way and say, who did they think was their public, and therefore who would be considered to be a new public. We haven't got completely away from communication to the public yet, because we need to mention the Stim case as well, another decision of the Court of Justice, a reference from the Swedish courts, Does a car hire company communicate works to the public when it hires out cars that have got in-car entertainment equipment in them? You might think, as I did, this is hardly a question worth bothering the Court of Justice with. How can that possibly amount to communicating works to the public and therefore infringing copyright? Well, the Court of Justice says that communication to the public only happens when the defendant communicates the content of the work, and that is not happening in the average car hire arrangement. Providing the physical facilities for communication to the public is not within the Restricted Act, and in particular look at Recital 27 to the Info Directive for confirmation of that proposition. So the Court of Justice thinks the same as we did about that. Well, we don't know that they thought that. The judges probably didn't say, why on earth are they wasting our time with this stupid question? But it gives a bit of clarity. It's useful to know. Let's move on to trademarks. I think despite having studied a large number of Scandinois television series, I'm not going to attempt the Swedish. Let's just call this the Swedish bus case. The trademark was the colour scheme for the buses. So it's not just a single colour, it's a combination of colours in various sort of shapes. And having got refused registration, they ended up before the Court of Justice. Refused registration, I have to say, by the Swedish Trademark Office. In some instances, it's well established that a trademark will be considered to be devoid of distinctive character unless it departs significantly from the norms generally applied in the sector concerned. This is a rule which has developed to deal with the shape of the goods or their packaging and the representation of the layout of the physical space in which services are provided. A rather curious form of words, which if I mention it's to do with the Apple Store trademark applications, you'll begin to understand what it's about. And under the 2008 version of the directive, this was particularly important, but it's the 2008 version of the directive which is the one that applied to the Swedish buses. So the Court of Justice basically said, yeah, we've got this rule for certain situations, but it doesn't apply generally. We don't have to consider in every case whether the trademark departs significantly from the norms which are generally applied in the sector concerned. That's a special rule that only applies in special situations. And where you're applying a sign to specific goods which are used to deliver a service, like a bus, the general approach is the right one to take. Look at the distinctiveness of the sign taken from the perspective of the relevant public, and that will tell you whether the trademark has got distinctive character or it's devoid of distinctive character, or in the awful language of the directive, devoid of any distinctive character. The word devoid I don't think needs a further intensifier in the form of the word any. So an interesting little case, but not one that I can see having widespread ramifications. Well, a trademark that is devoid of distinctive character, or which faces other absolute grounds for refusal, may be able to get registered on the basis of acquired distinctiveness, which basically means that by virtue of having used it for a while, and possibly spent a lot of money on advertising, the owner has made it work as a trademark. Jaguar Land Rover Limited wanted to register the shape of their Land Rover Defender model, or what people of my age would consider to be a classic Land Rover before they attached the trendy name Defender to it. And of course they wanted to protect it after they'd actually stopped making it. Ineos Holdings announced a long time ago that they were planning to produce a replacement for the Defender once Land Rover had discontinued production, and predictably therefore they opposed Jaguar Land Rover's application. It may be that Jaguar Land Rover only put in the application in the first place because they were concerned about what Ineos might be doing. Land Rover produced survey evidence showing that the shape of the vehicle was recognised by 20 to 40% of respondents. It would be interesting to know why there's that uncertainty about how many, but there we are. The judge Judge Melissa Clark, who's producing more and more judgments in the intellectual property field, said this was a significant amount, but it wasn't an overwhelming degree of recognition. But in any event, it didn't establish that the shape was recognised as a trademark, which is really the key thing. The percentage of recognition is a kind of proxy indication of whether the trademark should be registered. And on this basis, she said there was no acquired distinctiveness. And the examiner will very often set you a problem that's got a point about acquired distinctiveness in it. Trademarks which don't look terribly distinctive at the outset, but they've been around for a while. So this could well be a relevant point to take into the exam. Although, note, of course, it's not an appellate court. I didn't inflict my Swedish pronunciation on you, so I'm certainly not going to try the Hungarian. So this is just the Hungarian shape trademark case. It's a decision of the Court of Justice, so of course it's not considering Section 3, subsection 2 of the Trademarks Act, but because that comes from the directive, it's obviously relevant. I'll refer to the sections of the Trademark Act, though, so you can hang it on the right hook for your understanding for the exam. So we're looking at Section 3, subsection 2, B and C, not A. A is the trademark, well, the whole of subsection 2 is that a sign shall not be registered as a trademark if it consists exclusively of A, the shape which results from the nature of the goods themselves. You can't register the shape of a banana as a trademark for bananas. That provision wasn't in issue in this case. It's concerned with B and C. B is where the shape of goods is necessary to obtain a technical result, and C is where the shape gives substantial value to the goods. So there are two parts to what the court had to say here. Neither of them I think is particularly radical, but both of them are useful sort of clarification, consolidation of what the law's about, building on the filly shave case from yonks ago. So the court said that rules which deal with a shape which is necessary to perform the technical function, so this is sub little b, apply where the essential characteristics of the shape do this, and there are two steps to it. First of all, you identify what those essential characteristics are, using the representation of the sign as your starting point, but also taking on board other information, including the public's perception, which may be relevant. And then you ask whether those essential features perform a technical function. Unlike the first leg of this test, that's an objective test, and public perception isn't relevant to deciding whether they perform a technical function. So that's how you go about dealing with what would be Section 3.2b problems. And for Section 3.2c problems, shapes that give value to goods, the perception of the relevant public may be taken into account to identify the essential characteristic, and if consumers decide to purchase based on this characteristic, the application should be refused. In other words, Section 3.2c applies to make that shape unregisterable as a trademark. Next, there's a case on accepted principles of morality, which of course is a ground for refusing registration of a trademark. Another decision of the Court of Justice, and this time it's called Constantin Film Production GmbH against EU IPO, European Union Intellectual Property Office. So you can see it's going to be a case involving an EU trademark and refusal to register. Refusal to register as a trademark a very vulgar film title, in spite of the fact that it's in German. I think if you knew what it was, you would sort of guess what it meant, but I'm not going to trouble you with that. The court said this is not an abstract question, it's a question that has to be answered in context. It's not just a matter of bad taste. You have to ask whether it's perceived, whether the trademark is perceived by the relevant public as being contrary to the fundamental moral values and standards of society. And of course those standards change over time, and they vary from one country to another, even within the European Union. The court said that what's important here is the perception of the reasonable person with average threshold of sensitivity and tolerance, taking the concrete current social context into account. So I think two things to point out from that. It's the sort of average person rather than somebody of particularly sensitive disposition, and it's got to take full account of the context in which the trademark is operating. And notwithstanding the vulgarity of its title, this film had been used by German cultural organisations in schools and things, so clearly it wasn't regarded as particularly awful for these purposes, and fell on the acceptable side of accepted principles of morality. So this is one to add to a long list of rather entertaining cases which are probably of very little value given that the examiner has never been known to ask about them, but there's always a first time. Next, a case on bad faith. Of course, bad faith is another absolute ground for refusal of registration of a trademark. Sky and Skykick, a decision from the Court of Justice, then a decision in the High Court applying what the Court of Justice has said. And the Court of Justice began by saying that registration without an intent to use may amount to bad faith. It's well, it could be a ground for refusal of registration. It's more likely to be something that would sound in invalidity later on. So the Court of Justice said, in order to work out whether it's in bad faith, look and see whether the applicant was simply trying to undermine the interests of a third party, or in some other way trying to obtain an exclusive right for purposes which lay outside the function of a trademark. It's not at all uncommon to find businesses who would like to register a trademark for reasons which aren't strictly speaking anything to do with trademarks. And indeed, when the matter came back to the High Court, Mr. Justice Arnold looked at it and held that, according to the evidence, the claimant's registration strategy had been really to create an arsenal of weapons to use against third parties, and this was purely a commercial purpose. It wasn't to do with the function of a trademark as an origin indicator. It was simply a way of making life difficult for competitors, or indeed even non-competitors. So in that basis, the Sky registration was in bad faith. Not so important to know the outcome in the end, but as to know how to get there. And that's what the Court of Justice has obligingly set out for you there. Moving on to consider relative grounds for refusal, and simultaneously considering infringement, because the same rules apply in both instances. Some cases on dilution, starting from the point established by the Court of Justice in the Intel case, which says that where the dilution you're arguing about is detriment, because dilution comes in different flavours, where you're talking about detriment, you need to show that there's a change in the economic behaviour of average consumers. Planet Art and Photo Box is a High Court judgment. I think it's Daniel Alexander QC sitting as a Deputy High Court judge. And it tells us that you can identify this requirement for detriment, a change in economic behaviour of average consumers. You can identify it in a situation where the trademark owner has to make its trademark more different from the newcomer's trademark. So a newcomer's entered the market with a trademark which is kind of similar. The trademark owner finds it's a bit of a problem and therefore changes their own trademark to increase the distance between the two and to ensure that consumers don't confuse them. Well, confusion's not the issue in dilution, but you see what I mean. In those circumstances, that can amount to the detriment type of dilution. In the Sazerac Brands against Liverpool Gin Distillery case, another High Court judgment, we're told that in an unfair advantage case, so unfair advantage being another type of dilution, it may not be necessary to show that there's a change in economic behaviour of average consumers. And logically that makes perfect sense, because if you're looking for unfair advantage, you're not looking at it from the point of view of the average consumer, you're looking at it from the point of view of the owner of the trademark who's got problems with the competition ripping them off. So it makes perfect sense not to be looking at the economic behaviour of average consumers in that situation. Finally, the pre-exam update simply mentions Red Bull against Bighorn as an example of an unfair advantage case, and I don't think it serves any other useful purpose, but if you want to read any more unfair advantage cases, then there's one for you to look at. Now, a trademark which hasn't been used for 5 years or more without good cause will become liable to revocation. It's not automatically cancelled or anything like that, but it can be challenged, and certainly will be challenged in an infringement action, which is exactly the sort of thing that goes on in examination questions. If you're answering a problem question about trademarks and there's an infringement, you can be pretty sure that there's going to be some way of attacking the trademark without simply having to look and see whether you can analyse the law on infringement and find a way out of it. The trademark is likely to have not been used for 5 years, or it might be descriptive and therefore vulnerable to invalidity or something like that. So if the trademark's been put to genuine use, it won't be liable to revocation. But what amounts to genuine use? And in the Ferrari case, the trademark was Testarossa. They haven't made a car with that name on it for several decades now, I suspect. But they were selling used examples, and they argued that that was enough to support the registration of the trademark, and the Court of Justice agreed that it probably was. Distinguishing the situation where it's simply a resale of a used car with the trademark on it, that wouldn't be genuine use of the trademark, but using the trademark in connection with sales of used cars bearing the trademark could be genuine use. Now that looks like a rather nuanced distinction, which I think is probably best understood by saying that if I sell a Testarossa, which unfortunately I don't have one available, but if I was to sell a Testarossa, that's not me using the trademark. If Ferrari sell it, that's another matter altogether. Moving seamlessly into the field of patents, we begin with Regeneron Pharmaceuticals against Kymab, a case on sufficiency in which the Supreme Court took a strict approach, and because the disclosure in the patent documents enabled a skilled person to make some, but not all, the products within the claims, the Supreme Court said the sufficiency test is not satisfied, the patent's not valid. I think drilling down into questions about sufficiency and distinguishing ordinary sufficiency from biogen sufficiency and so on is beyond the scope of the exam, or at least beyond the scope of every exam I've ever seen. But when you've got a nice, warm, recent Supreme Court decision, it's certainly conceivable that the examiner had it in their mind when they wrote the paper. Next, the European Patent Convention prohibits patents for essentially biological processes. There's always been doubt about how this affected the products of essentially biological processes. For a long time this has been fairly liberally applied, and patents have been available for the products of biological processes. However, the Administrative Council of the European Patent Office changed the rules on the application of the Convention some time ago to exclude products produced by natural processes, as well as the processes themselves, and the Enlarged Board of Appeal, which is the body in the European Patent Office, which is convened occasionally to think through these big issues rather than considering purely individual cases. The Enlarged Board has therefore changed its interpretation of the exclusion, so now it's telling us that the products of essentially biological processes cannot be patented as a result of its decision G3 of 19 called PEPA. Well, the examiner does occasionally get into this area of biological processes and patents, but I don't think they ever get this far into it. It's important to know any decision of the enlarged board is an important one, but I don't suppose it's going to cause you any trouble in the exam. Mission and Hoselock is a Court of Appeal decision, and the Court of Appeal is considering whether a document that would not ordinarily come to the attention of the skilled person could nevertheless be prior art. The invention in this case was a garden hose, or a particular type of garden hose, and the prior art was a hose used to deliver oxygen in aircraft. So you can see why it might be something that wouldn't come to the attention of the skilled person in the garden hose field. The Court of Appeal said that the judge, Mr. Justice Muji, had correctly applied the principles set out in the Pozzoli case for dealing with inventiveness issues, so there was no reason for them to interfere with his judgment, which seems to me to be a bit of a sort of damp squib of a judgment, but of course it's not the Court of Appeal's job to second guess the judge unless something's gone wrong, and they found that he went through all the steps that he had to go through. He'd sat through the trial, he'd had all the evidence. The Court of Appeal hasn't, so they're not going to change anything. But nevertheless, it's quite interesting to know that a piece of prior art in a pretty distant field will nevertheless count against the inventiveness of an invention. And finally we come to the question of who's an inventor. Thaler against the Comptroller General. A case which, arose from a patent application filed by the owner of an artificial intelligence machine. He applied for a patent saying that the machine was the inventor, and the patent office rejected it because they said you've got to have a human being's name in the inventor box on your patent application. You haven't got it, so you can't have a patent. I think it's fair to say that he's an artificial intelligence enthusiast, and I think he's trying to show that the law isn't dealing adequately with artificial intelligence, particularly in this field. And if that's what he's about, then he's doing a good job of it, because it has to be said, it is abundantly clear that the Patents Act 1977 requires the inventor to be a natural person. Does the law need changing? Well, perhaps it does. Or perhaps there are other routes, and in fact the judge, which I think was Mr. Justice Marcus Smith, specifically refrained from speculating about whether the operator of a machine might be entitled to put in a patent application, but that would seem to be a pretty logical way to go if you want to reform the law, particularly because it's a path that was taken by the Copyright Designs and Patents Act in 1988 in section 9 subsection 3, which says that in the case of a computer generated copyright work, the owner of copyright in it will be the person who made the arrangements for the machine to do it. Would seem to be a very logical way of dealing with the problem of artificial intelligence and patents. Maybe that's something for future generations of students, and you can forget about it for the time being. Just get on with your exam. The very best of luck to you when you do write the exam. Thank you very much for listening. If you've enjoyed this, you might care to subscribe to my YouTube channel, but then again, if you've finished your intellectual property exam, you might have better things to do. If you've got any comments about this, please leave them on YouTube, and if you're continuing your studies, then there's lots of other stuff that I've made available for you in various places which might be of assistance.